Minutes of the last meeting, which is on pages 1 to 10. Obviously, we need to confirm and sign as a correct record. Do I have a proposer and a seconder? Yep, everyone happy? Yep, agreed. And we move on to item 3, which is declarations of interest. Do we have any?
Yes, I'd like to declare that I've been a London taxi driver for the last 33 years, but that has no effect on my standing in the committee. Tendering.
Thank you, Councillor Smith. No others, so we move on to item 4, questions on notice pursuant to Council Procedure Rule 38.
Thank you, Chair. I haven't received any questions.
We now move on to item 5, which is the miscellaneous licensing subcommittee on pages 11 to 14. And if we can formally receive and note these. Yep.
It's only receiving, but just needs another member of the committee to say.
Yep, Andrea. Thank you. And we now move on to item 6, which is the premises personal licences subcommittee. Again, if we could have somebody to Bill Davis. Lovely, thank you. Main item this evening, item 7, it's the report of the Deputy Chief Executive A1, development of a comprehensive and cohesive taxi private hire policy, and members can find that on pages 19 to 104.
Chairman, if it's okay with you, just want to just use the screens just to take you through the basics on which the foundations on which the policy is built, so the legislative position, and then Michael Cook, as the licensing manager, will take you through how we've got from the beginning to where we are today. Then we'll have a look at the recommendations and then open out for questions, if that's okay with you. It's worth, I think, just dwelling on the fact that the statutory guidance, and so as it's statutory guidance, we have to have regard to it, was issued in 2020 and then updated last year. And that says that each licensing authority should have a cohesive policy document that brings together all of their procedures on taxi and private hire vehicle licensing. And deals with vehicles, obviously in this sense, it's everything to do with vehicles and therefore drivers and operators. Why I say that is the underpinning element of the legislation is the vehicle, and that's the first bit, and then you build on that with the driver and the operator. It also goes on as statutory guidance from government to remind us all that the primary and overriding objective of licensing must be to protect the public. So that, above all, must be in the back of your minds whenever you're dealing with anything to do with policy matters and individual decisions when you've got either vehicle license, driver license or operator license matters in front of you, in front of perhaps a miscellaneous licensing subcommittee, then you have to have regard to that objective of protecting the public, and that should be foremost in your mind. The reason for the statutory guidance being updated in 2022 is that we had the Taxi and Private Hire Vehicle Safeguarding and Road Safety Act that year, and that provided for sharing of safeguarding and road safety concerns in relation to licensees. So the Act gave us an additional power to share information that individual licensing authorities had between us, and therefore the statutory guidance needed to be updated last year. In addition to that, we've got best practice, and that's been in place since 2010. Why am I mentioning all of this? Is because we've obviously, in preparing, drafting, considering the policy, the single cohesive policy which we have put before you this evening, is we've taken account of all of that. And I just want to be on the record that that has been the case. We're also aware, and has been reported to this committee, that the government was looking to update its best practice guidance, the one from 2010, and we've had a look at what was in that consultation document, albeit that consultation ended last year, and we're still waiting for central government to bring forward a new best practice document. So we're slightly in this grey area, that we've had a look at what the government, where the government's direction was going, but we still await an update to the best practice guidance. And we have no real option now, I would suggest, other than to press ahead with a policy, knowing that we may need to review it ahead of when we would otherwise like to review it, on the basis of what comes out from central government following its consultation on an update to the best practice guidance. I said look at the legislation, and fundamentally it comes from two separate acts, obviously supplemented by numerous other ones. Hackney Carriages, primarily the 1847 Town Police Clauses Act, and we've got the 1976 Act, as I've referred to in this slide, which is the Local Government Miscellaneous Provisions Act, a wonderfully titled, gives the game away, says what it does on the tin, except it doesn't, Act of 1976. And it says that vehicles used for private hire need a licence, as do those that drive them and operate them. Hence why I was saying the underpinning of all of it comes from the vehicle use, and that then defines the need for a driver licence and an operator licence for private hire vehicles. And the 1847 Act is itself supplemented by provisions in the 76 Act to deal with updating provisions of that 1847 Act, so that it's akin in many ways to the provisions that relate to private hire vehicles. So dealing with vehicles first, it says we've established that you need a licence. That's what that first provision was saying. Then there's that provision of section 46 of that Act that says we can attach conditions to a Hackney Carriage vehicle licence, and section 48 then deals with private hire vehicles and says we can't, as an authority, licence a private hire vehicle unless it is suitable in type, size and design, not of such a design to give an appearance to lead any person to believe that the vehicle is a Hackney Carriage, is suitable mechanical condition, safe, comfortable and insured. And we can attach conditions to both the Hackney Carriage and the private hire vehicles. Section 48, in determining whether a vehicle is suitable, attaches to it, in essence, how do you judge the suitability of a vehicle to be licensed? And it's common practice that you would undertake a test in order to satisfy yourself that that's the case. Yeah, there's other things, but I'll leave it there. I think drivers then, so that's vehicles, then you build on top of that drivers, and section 51 deals with private hire vehicles, private hire drivers, and section 59 deals with Hackney Carriage ones, but both effectively, or both do say that you mustn't grant a license unless you're satisfied that that person is fit and proper to hold that driver's license, isn't disqualified because of their immigration status, and they've otherwise held a DVLA license or equivalent for 12 months. And you can attach conditions to private hire driver licenses. There's also provision for you to issue badges for those individuals. It says that the license period should be, as a norm, 3 years, and it gives you the right to charge a fee to recover the council's costs. Whilst I put up on the slide sections 51 and 59 in relation to a new grant, the powers to suspend and revoke and not renew a driver's license are different. They're set out in section 61 of the Act and deal with where an individual has had an offence for dishonesty, indecency or violence, or convicted of an offence or has failed to comply with the provisions of the Licensing Acts, or has a new immigration status that makes them unable to hold a licence, or any other reasonable cause. Just on that, and it applies to all of the different licenses. Section 73 says that it is the duty of all concerned to assist an authorised officer of the council with their inquiries in relation to compliance with the provisions of the 1976 Act or the 1847 Act. So there is that requirement on all concerned to assist authorised officers with their inquiries. Lastly, private hire operators. Section 55, very similar to the provision in relation to drivers. It's a judgment as to whether a new grant, they are fit and proper to hold a licence and that their immigration status doesn't debar them from holding such a licence. And again, you may attach conditions to that licence. So everything in the policy is driven around these provisions. So that test as to suitability of the vehicle, the fit and proper test in relation to drivers and operators is there within the constraints otherwise of other legislation as to the information that we can obtain, and we can attach conditions to those licenses. What I haven't said is that in relation to considering applications for a vehicle, driver or operator, section 57 says that we have the power to require applicants to submit information. It's a nice wording, and the courts have looked at that and said that that can include undertaking tests. So all of those provisions, provision of information, so us asking for information from applicants and undertaking tests is also built on the provisions within the 1976 Act. Just think it's important to recognise that. So it is everything there is the foundation on which everything in that policy has to be built. We can't go beyond those provisions, and our duty fundamentally, going back to the very first slide, is to protect the public. So that's our role as a licensing authority. Michael's just going to go and take you through now how we've the process by which we've undertaken in order to get to tonight's presentation to you of the policy as it is in your papers this evening. And then I'm just going to run through the recommendations and just talk to those briefly before opening up for further questions.
So we first of all brought the policy to the attention of the Licensing and Registration Committee on the 3rd of November 2022, where the committee authorised officers to start looking into the policy, drafting it. That also involved a pre-consultation questionnaire that was published for an 8 weeks consultation. That commenced on the 14th of December 22. We then brought that back on the 8th of March 23 with a draft policy and the pre-consultation results for the committee to consider. On the 24th of July, we came back to the committee with a draft policy which was agreed to go out for consultation purposes. It included questions relating to the delivery and the introduction of points-based enforcement system. The outcome of the consultation that is gone through is going to be considered in tonight's pack. So that is where we are at the moment, Chair.
The Chairman, turning to page 20, we've got a series of recommendations there. First is that you consider the outcome of the consultation that is presented in the report. So you have those views submitted, including the views that were expressed at the consultation meeting with representatives of licensees. Then please, and so you've had that in writing, so I'm taking it that members will have read that before coming this evening. Consider the report, and if you're satisfied, recommend it to Cabinet. Why Cabinet? Well, that's because it's a policy matter and therefore falls outside of the remit of this committee. So you've done all the hard work, and then it goes off to Cabinet to reconsider with the recommendation from you as to what to do with it. We're obviously conscious that there are some changes of policy outlined in the document, and I think it's important that we look at the implementation of that, particularly for where that application will affect existing licensees, and consider appropriate timeframes and how that transition will work its way through. So rather than a big bang approach and see the new policy come into effect and commence and have teeth immediately following any decision of Cabinet or after a call-in period after a meeting of Cabinet, what we're suggesting to you and to Cabinet is that we develop an implementation program to see that introduced so that we can outline how we see that best going forward following any decision of Cabinet. Then if you could endorse, as it's set out in there, the approach to how we will deal with disclosure and barring service. By way of an update on that, the disclosure and barring service has allowed this council to go direct to it until a date in January. So it's not so much, that the thought, and I think the report says we were looking at this ending at the end of this month. We now have November, December, and part of January in order to look at new arrangements. As it says here, certainly initially, that would be through the existing company that the council uses it for its HR purposes to undertake disclosure and barring service checks on taxi and private hire driver licensees and applicants for those licenses. It may not be in the longer term or even initially that actually we stay with that company, and I think we'll be looking at the market to see what would be best, what works best, both in terms of what the costs might be, but also the level of service and the data such as it exists as to which company has less errors, so that we're not in a situation where we're going backwards and forwards with applicants. If we can get that through in the first run, that's obviously got to be in everybody's best interest to do that. So We do have a little bit more time by going direct to the Disclosure and Barring Service, but it does look like we will need to go through a third party, certainly from mid-January and onwards. So it gives us a bit of time to just examine what the market is like. Recommendation E invites you to authorise us to look at the fee arrangements. I think recognising that there is an amount of cost outlay for those wishing to come into the trade as drivers, and just let's have a look at how that fee arrangement is structured. We are undertaking a review of fees and charges in relation to the legal power, which goes wider than taxi and private hire, but to recover costs. So this will fit into that process, and we would hope to bring something back to you at the time that you're looking at fees and charges for 2024-25. And you know, because a number of you have gone through the knowledge test last week, that this is part of a process of reviewing the content of the knowledge test. Again, just looking and making sure that it is fit for purpose. So rather than not having a recommendation in here and not mentioning that, I think it's important that we do identify that that is a process that is still ongoing, and that is something that you will be overseeing as your committee. Chairman, I think before the meeting, we were talking about whether to have an additional recommendation in there about the intention to hold liaison meetings with representatives of the trade. So if there's a further recommendation that you want to put in around that, then obviously that can be put to the committee as well as the other recommendations I've just gone through.
Thank you, Keith. I'd just like to before we move on, thank the committee from the chairman's view. We've looked, we've listened, we've adjusted things. The licensing team have worked really hard, and I do think our meeting with the licensees did go really well. I think we'd be looking to add perhaps on item at the bottom here, Keith. We were saying perhaps another meeting in February, March with some of the taxi license people, because I think that connection is important. It's important that we listen to them, hear their views, and get that connection up and running, which I think has been possibly missing over previous years. The consultation, would have liked more people to take part, but I do believe what we are moving to go forward to Cabinet does bring in to listening to people's views and obviously implementing the things we need, which at the end of it all is to protect the public. You know, we've got to keep our public safe within the trade, and I do believe our drivers do their best to do that, but as a council we've got to make sure that we're doing our best as well. Before we move the recommendations, have any councillors got any questions? Thank you. No questions. So if everybody's satisfied, can I recommend that we move the proposed statement for the taxi private hire policy for adoption of the Cabinet to decide on block, including the meeting for March?
For absolute clarity, you're moving the recommendations A to F
on page 20.
On page 20, and you're going to add in the additional recommendation that you note the intention to hold a further liaison meeting in sort of hopefully February, March.
Yeah. Yeah.
If there can be a proposer and seconder, then that would assist the bill and.
That's the case.
Ooh. Arguments. Is it going to be Andrew or is it going to be Dan? And then if it would help, I think, if there was just a show of hands, just so that we've got very clear.
Lovely.
Thank you.
Thank you, committee. That's all sorted. Right, we'll now move on to item 8, which is the date of the next meeting of the committee. We're proposing the 31st of January 2024 at 6:30. So if that's all okay. And then we now move to item 9, which is the exclusion of press and public.
Chairman, if you're happy, then you can move item 9 and 10 en bloc in public session, as long as everybody's agreed to that they will adopt item 10 as in receiving it.
Yep,
Yep.
happy to receive. Seconder? Yep. Andrew. All agree then? I will now close the meeting. Thank you all.